Hey friends, in this video, we're going to talk about how you can get a green card after being in the United States for many, many years, and you have a removal order. Years ago, an immigration judge issued a removal order against you, and you've been stuck ever since then. I'm going to describe a process that we do weekly to help folks who are stuck. We help them to get a green card. So watch this video all the way until the end. For those of you who are new to me, welcome. I'm Latoya McBean Pompey, an immigration lawyer in New York, working with clients nationwide on complex immigration problems. Reach out to us. We have a new telephone number. The number is 1-888-462-4006. That's 888-462-4006. Reach out to us to book a consultation with one of our attorneys. Also, if you have not yet subscribed to our newsletter, subscribe now at mcbeanlaw.com/subscribe and get our free weekly newsletter. Now, let's talk about this problem and how it happens for so many people. Guys, no exaggeration. A whole lot of people are in this very situation. And here's how it works. When they come to the United States, someone convinces them to apply for asylum. And for some people, they actually do have an asylum case. And it might very well be a good case. But for other people, they don't have a case. Yet they apply for asylum and the case is not approved. And then they're placed in removal proceedings. For some people, they show up to court and they have the case litigated all the way until the end, until the judge issues a removal order against them. For other people, they don't even show up to court because they're afraid. And so in their absence, the judge issues a removal order against them. And then time goes on, they're still here in the United States, and they become eligible for a green card. But here's the big problem. In order to finally get that green card, they have to have the removal case reopened. And that is a very difficult thing to do. Very difficult thing to do, guys, depending on whether the motion to reopen the case will need to go back to the immigration court that issued the order or all the way up to the Board of Immigration Appeals. It is still a difficult process. And so for some people, they work with their lawyer, and then the case is not reopened. And then they just feel awful about it. And they feel stuck because, it's an awful position to be in. And so we see a lot of those individuals. And when we see them, we take a look at their backgrounds. We study the background carefully because here's what we're considering, guys, and where we've been very successful with. But every case is different, and I'm not guaranteeing any outcome in this video. But here's how we've been successful with helping people in this situation. We study the background, and then if we think the case is a very good fit, for us to reach out to ICE and ask them to help us. Now, you have to understand this. The case is no longer on the radar, so to speak, for the government, right? Maybe your removal order was issued back in 2000 or 2005, a long time ago. And so they're not actively pursuing you. You don't have an active case. And now you're asking them to do some work and consider putting you back on the docket or considering helping you. That's a very big ask to make. Yet we make it. We make it for the cases that we believe in and that we believe has a good chance of being approved by the ICE attorney. So we go to them with our ask, and if they say yes to it, then the motion is then filed with either the immigration court that issued the removal order against the individual, if the individual was not in court when the judge issued that order, or if the person was in court and they then appealed the decision and it didn't work out and they took their case to the board. We send the joint motion to the Board of Immigration Appeals, the BIA. And so, friends, that's how it happens. You have to get that process in place. And if you tried years prior, okay, and we've been successful with this, if you had a motion to reopen, go all the way to the BIA 10 years ago, 14 years ago, 20, however long ago, and it was denied, it doesn't mean that another one will be denied. And we've experienced so much joy in helping clients who have had motions to reopen denied in the past, and then we were able to do it for them. Now, once your case is reopened, what happens next is it's terminated. It's terminated. It's over, which means procedurally speaking that you can now then bring your green card application to USCIS for them to consider and issue you your green card. This process, however, guys, is available to individuals who have a pathway to a green card. If you're sitting there and you're thinking, wow, Attorney Pompey or McBean, whatever you call me, this is something I want to do. I'm in this exact situation. And if you're in this exact situation, just put in the comments, this is my situation. This is me. This is me. This is exactly where I'm at. And I know this is where you're at. I know it because you meet with us and I know what you're going through. So now, if this is you and you're thinking, I want to call your firm and get things going with this. Well, hold up. Don't call us quite yet, okay? And here's why. You need to have a pathway to a green card. We like to see the end from the very beginning. If we could see the end from the very beginning and you have a good background, good case, certain things are not on your record, then it is a great case to bring to ICE. Now, if you do not have a great case for this process to bring to ICE, for them to help you, well, we've gone around them anyway, and we go directly to the board, and we've been successful with that as well. But every case is different. So, but you must still have a pathway to show the board, the BIA, how you will actually get that green card in your hand. Now, that's obviously not the sign for the green card, right? But you get my point. You get the point. You want to be able to show them, this is exactly how I'm eligible for it. And I believe that I will get it, right? And so to be eligible for the green card today, you need to have a petitioner on the family side if you do not have a humanitarian process. Hear me out for a moment. This is an unedited video. Bear with me. I hope you find it valuable. If you find it valuable, type in below, this is valuable. This is valuable to me. Now, if you have a petitioner on the family side, your petitioner, the petitioner that can get you your green card here in the US, would have to be a US citizen spouse, or an adult US citizen son or daughter. Those are the two types of relatives that can get you your green card here through the process that I've described, not unless you are under 18. Okay, then obviously your parent can help you as well. But the individuals I'm speaking to in this video, I believe, are primarily adults who have been here for a long time, who had overstayed the visa, got themselves, unfortunately, in removal, and got a removal order. Okay, these are the individuals who this is applying to. So if you have a petitioner that could get you your green card here, terrific. If you do not have that petitioner that can get you your green card here, you'll need to have another type of process that can get you your green card here on the humanitarian side. Maybe VAWA, maybe you've been a victim of domestic violence, okay? That's one way. For other people, the U visa, it works, and we do those cases for crime victims. That's another humanitarian pathway. It works a little differently, but it's another pathway to a green card. So it has to be on the humanitarian side if you do not have one of those relatives I've described. Now, for everyone else who maybe you're saying to yourself, well, my husband is a green card holder. Will it work for me? Well, it's trickier. It's trickier for you. Why? Because you have unlawful presence on your record. You have all these years of being here without status. And so the government will not allow you to get a green card through that green card holder spouse. He would need, or she would need, to be a US citizen in order for that to work. What if you're saying to yourself, well, I have a US citizen sibling, will it work? And the answer is no. It will not work. And I will not need to elaborate on that, because the sibling process, as you guys know, it's not my favorite process. If you're here in the United States, it doesn't work very well. It helps individuals primarily who are outside of the United States, who have a clean background, and they're out there waiting for their visa to become available. If you say, well, I have a US citizen mom or daughter, will it work? Well, no. Here's why. It's trickier if you're the adults again, and your parent is the one filing for you. You will need a waiver, ultimately, a waiver. And then you have to go back home to a US embassy to finish that process, to consular process. Work with a lawyer, guys. If you're in one of these scenarios and you're thinking, will it work? Will it work for me? Will it work for me? Speak with a lawyer about that. Now, if you're saying, well, I've heard about cancellation of removal. I've been here for 20 years, more than 10 years, and I even have a child here who is a US citizen. Can this process, McBean, that you're talking about in this video help me, as you know, through cancellation of removal? Well, the first thing that I would want to know about you, if I'm going to consider something like that, is when did you arrive in the United States? Secondly, I would want to know, when were you placed in removal? When did you get that notice to appear in immigration court? When did that, when did that happen? I would also want to know what happened during the removal process, what was said, what's on the transcript, what happened. I'd want to dig deeper into all of those as well. Certainly look at the relative that you're pointing to now, saying, oh, I have this child, or, oh, my parent is sick, or whatever. I would want to look into those dynamics as well. But for many people, it won't work. Okay, I'm just going to say it that way. But for some people, it might work, because, I'd want to know, was everything done right during that removal process? Was due process, right? Was due process done correctly? Okay, guys, bear with me. Yeah. Was due process, were things done according to due process? These are all the questions that we would want to ask and dive deeper to give you that answer that you're seeking. So to summarize, it is possible for you to have been here for 20 years, 24 years, and you have an old removal order, and now you could actually get a green card, and we see it and we make it happen a lot for the clients who come to us. But every case is different. We never guarantee that outcome, that your case will have the same outcome. I'm not guaranteeing that. Consult with a lawyer to talk about your unique situation and whether your case is a good case for reopening. Contact us again at McBean Law at 888-462-4006. That's our new number. And book your appointment with us if you'd like to go deeper and know our thoughts about your case. Guys, thanks so much for watching this video. It's great to be back with you, and I will see you in the next one. Bye-bye.